Do we have Klaus here, or Mr. Andrews here from the state? Is one of the Klaus brothers here? Jay, are they outside?
No.
All right.
Mr. Andrews has several family members that are in fact they'd be allowed to come in the building.
Sure, let me fill in the seat, unfortunately. I mean, you can't understand. Okay, first one up is Erich Nowsch, time set for sentencing. Mr. Klaus, are you ready to proceed?
No, Your Honor, we are not ready to proceed.
Why not?
Last Friday, our client indicated that he would be filing via normal mail a motion to withdraw his plea that apparently somebody over at the jail library helped him fill out. I don't believe the court has received it at this point. There have been several communications with our client since then, and we're not entirely clear what the entirety of the basis for this is. I would be uncomfortable going forward when PNP gets us the PSI, with 24 hours to prep for it, but that's not really the larger issue. I would be complaining about that anyway, we're screeching a little bit about that. But a larger issue is this. First off, our impression, not entirely clear in talking to Erich, is that what we're dealing with here, and certainly in any such case, you've got a motion to withdraw a plea, a prominent figure is the relationship between the client and the attorney, both talking about ineffective assistance, and Erich has mentioned to us that there were things that were not discussed between us. We're not clear at this point what those are, despite making an effort to determine that. That means that we're in a little bit of a difficult situation. We're also in a difficult situation because he brought up either a legitimate defense or actual innocence, we're not entirely sure. And that means that in terms of making an argument at sentencing, we are a little bit hamstrung as to what we can argue. We do not know where this motion is, and we asked Erich to reconstitute it, and he was unable to do so. My understanding is what he has here today is something he wanted to address orally in court, and we really haven't had an opportunity to go through it. So I don't know that that's entirely wise, but he's got oral arguments he wants to make with regard to withdrawing his plea. But in any event, the state's going to bring up a couple concerns, one of which is raised in the PSI, and I don't entirely understand it. The PSI mentions that the Meyers family won't get insurance money. I don't know what insurance money they're talking about until we have sentencing. I don't exactly understand that. But what I will say is, given the magnitude of this case, given how much time and effort has been put into it up to now, and given the relative ease with which this matter can be addressed in one form or another, or at least the relative clarity with which it can be addressed if we have some further proceedings, I think it's unfortunate that they might have to come back for sentencing, but I think it would be prudent if you order us to go forward, having said that I think at this point we have some effectiveness issues. We will go forward having made that record. We prepare a sentencing memorandum, haven't filed it. It is a sentencing memorandum that recounts the evidence and the statements rather than making any direct statements on behalf of Erich. And we can do that. We read it because we weren't able, given the situation, to get it done in the timing we wanted to have an actual memorandum filed. However, I don't necessarily think that's wise. By way of a compromise, if the Meyers family wants to speak today, we have no objection doing that and then getting this solved. I don't know that the state would want to do that, though, without knowing what's going on with Eric's plea. If they do, that's fine with us. But I just, we'll do whatever you want to do. I think we've made a record. We will, after reading, if you order us to proceed with sentencing, and we read the sentencing memorandum into the record, we'll provide a copy to the court, not for the execution to look at it for our sentencing, but just so it's there. This is of any later proceeding.
So you have not had an opportunity to meet with your client after you learned that perhaps he wants to withdraw his plea?
That's not accurate.
We actually have met with him, several times. All that Mr. Nowsch could tell us were some large conceptual issues that he had placed in the motion. He did produce proof that he had mailed them. However, he didn't retain any copies. And again, we asked him to reconstitute that motion with an eye towards being able to act thereon, but he wasn't able to do that, Your Honor. So what we're left with is a position where, based upon what he's told us, there are some ineffective claims that he has made within the ostensible motion that he has mailed off. He cannot go into detail with us regarding those. He can only recount in large S what he's placed in that motion.
Mr. Nowsch, I'm not going to ask you for the basis of your motion. I just want to know from you, do you wish to withdraw your guilty plea?
Yes, sir.
Okay. Just so you know, just because you wish to withdraw it doesn't mean it's going to be withdrawn. I have to see if there's a legal basis for that. But if that appears to be your desire, I think you need to meet with your client, your attorneys further. And if there's a conflict, then we'll deal with that down the road. Okay. Mr. Sandler, Mr. Hammer, anything regarding Mr. Nowsch?
Well, in essence, what we have is a adult defendant who was entered a pleas of guilt over a month ago before Your Honor in a thorough and complete canvass that claims to have sent a motion to this court to withdraw his plea, that he's unable to or unwilling to communicate the details and the basis of it to his counsel prior to this proceeding. And if I understand counsel's representation is that this defendant mailed it to the court or to some entity, and as a result is by operation of that act expressly or implicitly asking for a very significant sentencing to be continued. I think it's improper. There's nothing before this court. There's no motion before this court. Counsel's comments about prudence and caution and effectiveness. One of the things that the Nevada Supreme Court has said repeatedly in addressing the flood of litigation about moving to withdraw pleas prior to sentencing is addressing the temporal time of when the plea is made as to when the motion to withdraw is made. The court, time and time again, in their vectored approach to this issue over the past several decades, has found that to be a compelling assessment to make. The earlier it is done after plea, based upon, if nothing else, common sense, would indicate that that would be something the court would normally consider and has upheld as being within a fair and just confines, the kind of the standards the courts to apply in situation if that's what this is. And as this court clearly can tell, there's no motion before this court. There's no basis, there's no ability for you to assess whether independent counsel needs to be appointed because of some claim of ineffective assistance, what that is, whether it's cognizable at all. We are prepared, the state and the Meyers family, by law, by statute, and by constitution, to proceed to sentencing. And I appreciate counsel's offer to waive their rights to address the court in both their email to the court prior to today's hearing about this issue. On behalf of the Meyers family and on behalf of the state, we elect not to waive the right to address the court last in sentencing this matter.
All right, thank you. Well, it's not clear to me, obviously, there's no motion in front of me, but I've been advised that there's maybe claims that the two of you were ineffective, that you may have misled him. I don't know what the basis is, but I need to clear that up. So I'm going to come back, and we're going to come back in 2 weeks. Okay? Gentlemen, meet with him, and see if this matter can be resolved. If we can't, if he's making allegations against you, then we need to find someone to file appropriate motion. If it's the issues in question are resolved, then we will go forward. I know we have people here from various families here, hoping all of you understand that we want to get this done once, we want to get it done right. And so I'm going to make sure that, all the bases are covered here. And so let's come back in 2 weeks, and the gentleman meet with Mr. Nowsch. And maybe there's just a misunderstanding, and he does wish to go forward, or maybe he's making allegations against the two of you. We need to have that cleared up. Okay? And counsel, if you, after meeting with your client, if it's more than just a misunderstanding that he does wish to go forward, then please advise myself, via email CC the state to say that you will be going forward on the sentencing on the state that we give you. Okay? If not, just say, looks like we're going to need to have a motion filed or something like that.
So if I understand the court correctly, the 2-week date we're going to be getting is a status check for sentencing that we converted.
Well, if you tell me he wants to go forward, then we'll be ready for sentencing.
Okay.
But please advise as soon as possible so I can re-prepare as well as the state.
Understood.
Judge, I've been advised by the family that if the date that you're going to give is the potential of a sentencing date, that 3 weeks is the earliest that they could be
I
available.
think that's fair. They were here today. There's proper notice. We'll go out 3 weeks, Carol. Now, if I understand Mr. Stanton, and we have Mr. Tomczak and Mr. Nelson here, this is a contingent plea.
It is.
So if for some reason that Mr. Nowsch's plea is withdrawn, you're going to undo the negotiations for Mr. Andrews. Is that correct?
That's correct.
All right.
Just so for the court's application, I talked to Mr. Stanton about this yesterday. We did prepare a sentencing memorandum.
I received it.
We are prepared to go forward.
Right. But we can't go forward on him because it's a conditional plea, and if there's a legal basis and I grant his motion, and it's going to be unwound, and your client's going to go to trial on the murder charges.
Understood. I just wanted to convey that we're not having the same issues as.
I understand. All right, 3 weeks, Carol.
And if I could ask,
Sure.
if that's going to be a Thursday date, we have the Tuesday of that week, is that possible?
It'll be Thursday, May 12th.
Could we have the
You have a
Tuesday of that
Tuesday?
week?
And is that fine with our victim speakers? 3 weeks on Tuesday? Here's your date. Give us the specific number.
May 10th.
Perfect, thank you for that accommodation.
All right, see everyone back on the time again, please. Please advise me one way or the other.
All right, all family members for Andrews and Nowsch, please exit the courtroom, please.
Good morning, which page?
I have Ms. Reeves on page 17. Copy for